SJC-12542, Loretta Sullivan and another v. Sleepy's LLC and another.
Mr. Churchill, good morning.
Good morning, and may it please the court. The key essential requirement of the overtime law in Massachusetts is to pay an hourly rate, a premium hourly rate for each hour of overtime. There's no other way that the three purposes of that law, which this court recognized in Malloy, could be achieved. Those three purposes are to reduce the number of hours worked, to encourage the employment of more workers, and to compensate a worker who works for a long work week. And to get concrete here to demonstrate this point, here, for example, you could have somebody who worked 35 hours a week and received a draw of $625. If that same person worked 45 hours a week, they would receive the exact same draw. In other words, they received zero compensation for overtime hours that were worked. The same is true if they happen to earn a commission. So if they earned a commission based on a sale in their 39th hour of work, they're going to continue working for 40 hours, 41, 42, 45 hours, 50 hours, and if they make no further sales, they're earning no further commission. So there is no way to satisfy the three requirements, the three purposes of the overtime law in any other way.
Can't be that clear. The Department of Labor Standards issued two opinion letters to the contrary.
Right, so I think there's, the first thing to say about that is that the purposes of the statute as recognized by this court is what's going to control this case. The regulations that the DLS promulgated make clear that the position that we're taking in this case is the one currently supported by DLS. Those opinion letters, if you read them carefully, as I know the court has and will, the focus there was not on the precise issue before this question. The question was, what is the rate going to be for overtime when you have a commission-only employee? And that issue came up because commissions are excluded from the calculation of the regular rate. So the answer in those opinion letters is that the overtime rate is 1.5 times the regular minimum wage.
Do you have any dispute, both of you, as to whether or not your 100% commission employees are entitled to both overtime and Sunday premium pay? You have any dispute about that?
I don't believe there's any dispute about that.
Any dispute about the fact that the regular rate is state minimum wage, unless the employer sets a higher rate?
I don't believe there's any dispute about that.
The only thing that's in dispute then is whether or not, I mean, sort of whether or not you get extra on top of it, right? On top of the commission and draw.
Correct.
That's really what's at stake.
That's
here.
what's in dispute, Your Honor. That's correct.
Could you interpret the language? Because I don't find there are two provisions. There's the statutory provision and then there's the regulation. In the statutory provision, they just say that just talks about rate, right? Meaning the rate, we don't look at the amount you're paying in terms of, if you pay in a draw or in a commission, we don't look at that in determining the rate for overtime, right? The rate for overtime is 1.5 times minimum wage, right?
Right.
But I have a lot of trouble understanding exactly what the second provision, the regulation, says. Can you walk us through the regulation?
Right, so you're talking about section 2703?
Yeah.
Section 3?
Yeah.
So the regulation...
Well, the language I'm talking about is whether a non-exempt employee is paid on an hourly, piecework, salary, or any other basis, such payment shall not serve to compensate the employee for any portion of the overtime rate for hours worked over 40 in a work week, except that this limitation only applies to the 1/2 portion, and then it goes on about a bona fide fluctuating work week basis. What is your understanding of how that works?
Yeah, I think the meaning of that provision, I believe, is quite clear, which is that any amount of compensation that has been paid for work that was done in a regular work week cannot be counted towards the payment of overtime. So
But the first language says, shall not serve to compensate the employee for any portion of the overtime rate, right? For hours. It uses the word rate, right?
right, well, I think what that means is that means the overtime that is due, when it says overtime rate
But
there.
you sort of use the word rate in the other statute a little differently, don't you? I mean, when we're talking about the statutory language as opposed to the regulatory regulation, you focus on the meaning of rate in a different way, don't you?
Well, I think when you're looking at this language in the regulation, it's undisputed that in order to calculate the amount of the overtime rate, you're going to look at what was paid for a regular rate, excluding things like commissions, bonuses, draws, things like of that nature. So this language here can't mean that those other things, hourly, piecework, salary, other basis, aren't included in the overtime rate. That would make no sense, and it would be contrary to the very definition of an overtime rate and how you get there, which is
But
one of
the
the...
Appleys, their definition is that when you're trying to figure out in the subsection 3, the second paragraph, where it says such payment,
Yes,
that such payment, what does such payment refer to? They say it refers to, in the first paragraph under overtime rate, such regular hourly rate.
I think the only way to make sense of that provision that we're looking at is it refers to pay that was given to the employee for work that was done during a regular work week. So you can't take money that you would have gotten anyway and say that any portion of that money counts towards the payment of overtime.
But what they're saying is that that only refers to when you're dealing with an hourly rate, because they go back to the first paragraph of subparagraph 3. You understand that's their argument, right?
Yeah, but that doesn't make any sense because in that section there, it says hourly, piecework, salary, or any other basis. So it wouldn't make sense to then limit the next provision to mean just an hourly pay.
But if you're right, why did they use the word rate in the second? Why didn't they write, shall not serve to compensate the employee for any portion of the overtime amount, owed or something like that, as opposed to the rate? 'Cause
What? I can't answer that question, Your Honor, but I think the more important point is that it's clear in context, and the only thing that makes sense is to read it as the overtime amount that is due, because you can't make sense of overtime rate there any other way.
But you see, you like rate when you're reading the statute, right? Because when you read the statute, sums paid as commissions, drawing accounts, bonuses, or other incentive pay based on sales shall be excluded in computing the regular rate. You like that. You like rate meaning rate there, don't you? Because rate there is the basis for your saying that all that stuff is talking about is rate as opposed to amount, right?
Well, if the question is that is, when you talk about an overtime rate, and the starting thing I said was that has to mean an hourly rate, an hourly amount for each hour of overtime. That's the only way you can comply with the three provisions, the three purposes of the overtime law, is to think of an overtime rate as an hourly rate for each hour of overtime. That's written in the regulations elsewhere. It says in the very first part of Section 3 here that the overtime rate is 1.5 times an employee's regular hourly rate. So 1.5 times an hourly rate is another hourly rate. It also is the same thing under the FLSA. There's a provision of the regulations that says overtime rate is an hourly rate.
I get the rate makes perfect sense to me but the problem is we've got amounts and rates sort of blended into sentences, and they don't completely line up. She's going to get up and say that we shouldn't read rate there as rate in the first part. We should read that as amount, and then we should read the second part as rate. And you're doing the opposite. That's why I get a little confused here.
Well, I think
you're both using rate and amount to your own purposes. And they don't quite line up because the statute and the regulation are not neat fits, right?
Well, I guess I would start with this. You can't possibly comply with the three purposes unless you pay a certain hourly rate for each hour of overtime. That's kind of the central premise of our position.
But they say, so say this person, they could easily have created a draw that met your requirements, right? That paid $125, probably, depending on how many hours you worked. If they said, instead of putting $125, they had, you're gonna get your hourly rate, we're gonna give you a draw that constitutes the minimum wage times 40. And we'll pay you overtime at 1.5, because that number, they can make it below 125, right? Had they done it that way, we wouldn't be here probably.
So here's the difference, though, is the way it's structured now, if somebody works, say, 5 hours of overtime and they make no sales,
Right.
they're not getting any extra compensation for those 5 hours. If they did it the way you just described and said, all right, you're gonna get at least 1.5 times something, then if they work those 5 extra hours, they're guaranteed to get paid for those 5 hours.
I agree, but aren't you in danger of hurting the employees by what you're doing? Because you're encouraging them to, instead of giving them 125, to give them the minimum wage times 40 plus this breakout afterwards.
Well, that's a consequence of the overtime law generally. It's the same argument when you say, as the appellees did here, aren't you going to hurt employees by giving employers an incentive to limit their hours?
Right.
Well, yes, but that's what the legislature did when they passed the overtime statute, very knowingly. And as this court recognized, that's the way the law has to be interpreted.
So if the regulation means what you want it to mean, how do you explain the fact that when it was being adopted, nobody knew that this was going to be a big deal? It could be a sea change, but nobody knew it was going to be.
So I take issue with there's nothing in the record to demonstrate that this was viewed as a sea change or that it constituted a sea change.
You don't think all of a sudden having to pay this is going to be not a sea change?
What we're asking is 100% in compliance or in harmony with what always has been required under the Fair Labor Standards Act. It always has been the case that you cannot pay a lump sum for variable amounts of overtime and then try and back into an overtime payment. This court has never addressed this issue one way or the other. The appeals court never addressed it one way or the other. So if there was a widespread practice out there, which there's actually no record evidence of, then that's something that was being done in contravention of the general principles of the
I think the
FLSA.
Department of Labor Standards suggested that before, and then you got August of 2016 or wherever it was, there's a change, and there's nothing about, no publication about a change in interpretation.
Well, I think the issue with the guidelines is the question that was put to DLS was, what is the rate we have to pay given this problem that commissions don't count towards the regular rate? And then the commission, the department answered that and said it's the minimum wage. And then in that first opinion letter in 2003, they gave examples. And I think that's probably the source of confusion. The examples that were given there all were based on weeks that had the exact same number of hours, 50 hours a week. Now that's permissible under the FLSA as well. There's a section of the regulations that say, not surprisingly, if you work the same number of hours every week, week in, week out, you can get paid the same amount. But the the very next section of the DOL regulations say that if you have variable amounts of overtime, you can't just pay a flat amount and say, oh, there's got to be overtime in there somewhere. This has got to be enough to cover it. And the reason for that is it doesn't satisfy the purposes of the overtime law. It doesn't create the disincentive to have employers have people work more hours. So here, if you're getting $625, whether you work 40 hours or 45 or 50 hours, Sleepy's has every incentive to keep them there working and working and working. It's at no cost to them.
Can I ask you a question about where is the purposes, where do they derive from? It's just us?
No, so this court in Mullally looked at the recognized purposes of the overtime law
Recognized.
in the Fair Labor Standards Act.
Now, that's another thing. You sort of pick and choose when you like the FLSA, don't you?
No, No, so I think,
Sometimes it's relevant to interpreting the statute, sometimes it's not. Sometimes it's, we've adopted the FLSA, sometimes it's not.
no, the only thing that we disagree with in terms of the appellee looking to the FLSA is they looked at, here's the congressional reason for exempting commissioned employees. The Mass Legislature expressly went in the other direction and did not exempt commissioned employees. So it's improper for the appellee to say, look at these cases talking about why Congress exempted commissioned employees when the Mass Legislature never exempted commissioned employees.
So other than that, we're always to look to the FLSA for understanding the purposes and understanding everything else?
Everything else in our position is wholly in line with the position of the Department of Labor and with the FLSA.
Okay.
So the auto dealer's brief says that the sky is going to fall down and that actually the amount to pay has to be $30 an hour and that employees are going to get the commission plus this $30 an hour. Why isn't the sky falling down if this happens?
I think it was actually the economy is going to
I'm using my-
crash.
Yeah, I was using my.
I mean, I think that's clearly hyperbole, but the proper reading of this regulation, I think the only reasonable reading of it is simply that you can't take money that somebody was going to get anyway for working regular hours and try and use some of that to satisfy your overtime obligation. So here, our position is if you work another 5 hours of overtime, you're entitled to 5 hours times 1.5 the minimum wage. And if you happen to earn a commission, you would have got that commission whether you made that sale in the 39th hour, the 41st hour, the 49th hour. It's apples and oranges. You have to be guaranteed pay for overtime. That's the only way that the three purposes underlying the overtime law are going to be satisfied.
Can you do the math for us, just so I understand? So
That would be
this person has a commission, they get a draw of $125 a day, is that right?
Yes.
So do the math of what, so if they work 10 hours of overtime, how much would they get?
Well, if they work 5 days a week,
So they work 5 days a week, but I take it we don't care how many days a week they work. It's how many hours over 40, right?
so are you asking how much overtime they would get?
Well, I want to, if you win, I want to make sure we give out the right number
Right,
for you.
sure.
So if they have a draw of $125 a day, and just pick a couple of numbers for overtime. An employee worked 10 hours of overtime.
Right.
How much are they entitled to?
They get 10 hours times the minimum wage times 1.5.
Okay, and that's on top of the 125 a day they get.
Right, because they would have gotten that even if they didn't work overtime.
What if so it doesn't matter how many sales they make or when they make the sales?
Correct, because you're going to get that anyway. If you make that sale in the 39th hour, you get that commission. If you make it in the 42nd hour, you get that commission. It's totally a different issue. You have to be paid for those overtime hours.
And the
What about
minimum,
the Sunday statute? This is a little bit, you don't have to work the 40 hours first. You can work 10 hours and still be entitled to it if you work the Sunday, right?
Right, so we are, as you saw from our brief, our argument on the Sunday hours is
Very minimal.
completely dovetailed on the overtime. Same
Except that I
argument.
just want to be clear that you didn't have to work 40 hours first.
Correct.
so every hour they worked on Sunday, they get time and a half for. So just to complete the hypothetical, so they worked 10 hours of overtime that week, and they worked 5 hours on Sunday. How much do they get?
Well, they'd get just the 10 hours of overtime because you,
Oh, so you subsume the Sunday time
Yes.
into that? Okay.
Don't double count.
yes, that's under statute now, and this court held that.
Okay.
Anyway.
Actually, police use that Swift case is consistent with their position that there's no double payment.
Right, that is what the court held with respect to overtime and Sunday pay, but that's totally different here because, as I said, the commissions and the draw are not paying them for overtime hours they've worked. It's paying them for commissions they earn based on sales whenever the sales are made.
Okay, thank
All
you.
right, thank you.
Ms. Saunders?
May it please the court. This case presents the exact same situation that this court looked at in the Swift case, because the plaintiffs here are arguing that they should be paid overtime and Sunday pay twice. And this is because the pay plan that is at issue here, and the pay plan in general, 100% commission pay plan, based on a draw versus commission pay plan, is prospectively designed based on years of opinion letters issued by the Department of Labor Standards to ensure that the 100% commission employees receive time and a half minimum wage for all of their overtime and Sunday hours worked.
Can I ask you what I asked the other council, which was, do you agree that they are covered by the overtime statute and by the Sunday statute, these employees?
We agree that they are, yes, Your Honor.
Okay, and you agree that it's minimum wage times 1.5?
Yes, Your Honor, that's the proper
The only
rate.
thing we're arguing about is whether or not it's on top of or not.
Yes, exactly, Your Honor.
Okay.
So in this case, the issue, the crux of the case is whether or not these employees, who the employers have already set up a pay plan whereby their draws and commissions are designed to compensate them for overtime and Sunday pay.
How do we know that?
Whether they're entitled to
How-
additional pay.
How do we know that? Because you could have easily done just that. You could have set up a thing saying, your draw is 40 hours times the minimum wage, and we're going to assume you work 10 hours of overtime. But you don't do that. There's no record that that's what you do. You just give them $125 a day. So why should we, and isn't that inconsistent with our case, which says you don't get to rejigger things? The other case, I can't remember which one it is at this
That would
point.
be Mullally, Your Honor.
Yeah, so why, aren't you right in the teeth of that problem?
So, Your Honor, in this particular case, the plaintiffs have stipulated that they were compensated for all of their overtime and Sunday hours worked at 1.5 times the minimum wage.
How did they, I don't understand how they would stipulate their, if you, how would they have stipulated to that?
They
They
stipulated
didn't get
to
any
that,
extra pay. They got $125 a day.
they didn't get extra pay, but they stipulated for the purposes of asking the court, the district court, to certify the questions, and there is no question.
What page, what does the stipulation say on that?
It is in the appendix.
But by that, all you mean is that they stipulated that the amount that they received was greater than 40 times the minimum wage plus 1.5 times the minimum wage for the hours that they did overtime.
That's correct, Your Honor.
That's all that they stipulated to, is that by your calculation, under your theory, they would not be in violation, or you would not be in violation of the minimum wage, I mean, of the overtime statute.
Correct, Your Honor, and just, Justice Cafter,
Yeah,
it
no,
is,
that was
it's
my-
on the record 28, page 28.
But that, I don't see that as a, that just frames the question. You know, it doesn't stipulate that it's overtime.
Which stipulation was it? 1, 2, 3, 4, 5, which,
The very last one, number,
which reads, during the relevant time, the
Yes.
draw and/or commissions paid to both the plaintiffs always equaled or exceeded the state minimum wage for the first 40 hours, and 1.5 times the state minimum wage for hours worked over 40 hours and on Sundays?
yes, Your
And you
Honor.
think that's some kind of huge stipulation, do you?
No, Your Honor, I'm just saying, for the purposes of this case, the issue and the certified questions ask this court to assume that the employees, the 100% commission employees, have received, through their draws and commissions, 1.5 times the minimum wage for their Sunday and their overtime hours worked. And we'd submit, Your Honor, that that is something that the legislature contemplated, because in the overtime statute, the legislature specifically decided to treat 100% commission employees differently. The legislature expressly stated that the draws and commissions should not be considered part of either the regular rate or the overtime
And
rate.
where did they do that?
It's in the overtime statute.
Where? In the overtime statute? What-
It
what
says
part of
sums paid as commissions, drawing accounts, bonuses, or other incentive pay based on sales or production shall be excluded in computing the regular rate and the overtime rate of compensation.
But that's rate, not amount. That makes complete sense. We're not going to do what you do, which is divide their $125 a day into, you know, regular pay and overtime pay. Overtime is going to be defined separately by the minimum wage, right? Isn't that all that section says? It doesn't do what you want it to do, which says you basically, if you set an amount that's greater than 40 hours plus overtime times minimum wage, you're protected. They don't do that.
Well, Your Honor, I would submit that the legislature intended through that language to bring the Massachusetts law in line with the federal law, with the Fair Labor Standards Act, which this court has stated in several different cases, including most recently in the Cassius case, that the overtime statute was intended to be, you know, quote unquote, nearly identical to the FLSA.
But not in all respects.
Not in all respects, but in the
How do we
SWIFT.
know it's not in that category in connection with what you're pointing to?
Well, because in the SWIFT case, Your Honor, this court stated that the intent of the legislature was not to provide greater or additional overtime compensation to employees than under the FLSA. So by accepting out the inclusion of commissions and draw, and by essentially pointing employers to the minimum wage, the legislature has essentially brought the Massachusetts overtime law in line with the FLSA without adopting the exemption, because under the FLSA, the employees still receive overtime, and under the 100% commission pay plans, which employers in the Commonwealth have designed for many, many years in reliance on the Department of Labor Standards guidance, the employees receive premium pay for all of their overtime and Sunday hours
can you
worked.
tell,
It's just
though?
not called that on their pay stubs.
How can you tell when you don't take into account how many hours the employee works per week? How do you know that you're paying them the overtime that they're due? I don't.
Because these kinds of pay plans really exist in the world of big ticket items. So here it's mattresses with Sleepies, and in the case of the amicus briefs, it's cars. So these are the kind of jobs. These are not, you know, people who are necessarily getting paid minimum wage as a matter of course. These are jobs where the sales are fluctuating depending on consumer demand, where they're very large ticket items, like a house, where you would earn a very high commission rate.
But you'd still have no way of knowing if somebody had passed the overtime line.
Well, they do still track hours, and they do still,
They do. Where do they track the hours? I didn't think you did track the hours.
no, they do still track hours.
But do they give them, if they reach over, say some hardworking person worked 80 hours in a week, is there a time and a half that somehow kicks in somewhere that, I assume you don't pay anyone more than $125 and their commission. You never do this overtime calculation, do you?
So,
Do you ever give someone a check that says, okay, here draws 125, you were a crummy salesman, you worked 80 hours that week, you did no sales, but because you worked 80 hours, you get a time and a half plus the 125?
So just to clarify, the facts in this case pertain to Sleepies, which doesn't exist, and the 125 pertain to 2014, 15, and 16. So that's what we're dealing with in this
But do
case.
my hypothetical.
So at that time for Sleepies, I'm not sure what they did, but
So hold it, when we go, all we got is the record here. Is there any employee in this record who worked at Sleepy's that got a check for 1.5 times the number of overtime hours? I assume the answer to that is no, right? Because you're saying always 125 covered minimum wage plus overtime, right?
correct, and it did cover that. That's the facts of this case are, with these particular two plaintiffs, it did cover that. And the certified question asked this court to assume that in a scenario where a 100% commission employee receives compensation that equals or exceeds 1.5 times overtime and Sunday hours, whether they're entitled to additional separate compensation. And that's the crux of it. What the plaintiffs are arguing is that even though employers in the Commonwealth can design a program, which they can and they have for many, many years, whereby their employees will be compensated for all of their overtime and Sunday hours at 1.5 times the Massachusetts minimum wage without some separate compensation. The plaintiffs are asking this court to treat a draw, which is, it's not the same as a lump sum, but to treat it as a lump sum and to require those same employers to pay their employees twice.
Well, that's not what they're saying. That's what you're saying. What they're saying is that it doesn't matter if you work 35 hours or if you work 50 hours plus all day Sunday, 58 hours a week, you're going to get the same check, and that doesn't serve the three purposes of the overtime law, which is to have more employees hired, have employees work less time, and to make sure that employees who do work more hours are compensated appropriately. Those are the three goals of the overtime statute. And they're saying, I'm not saying they're right, but that's not their argument. They're saying that if you get the same amount of money, no matter how many hours you work, it's not consistent with the goals and the purpose of the overtime statute.
Well,
That's
Your
their
Honor,
argument.
I understand, Your Honor, but the overtime statute was not, does not, and Mullally does not say that the overtime statute was designed to provide extra separate compensation to those employees. It just says that it was designed to ensure that they receive compensation, and that's what the overtime statute says as
And
well.
what they're saying is, how can you say that they received compensation for overtime if they get the same amount of money whether they work overtime or don't work overtime? What's the response to that argument?
Because in some situations, they actually receive a lot more than just the minimum. This is, the pay plan is designed to ensure that there is a cushion for having, that would be the bare minimum that they receive, which would be the 1.5 times minimum wage, but they have on the upside the possibility of earning a lot more. And the Seventh Circuit, Mullally is expressing the same, the legislative history of the FLSA, which the Seventh Circuit dealt with also in the two cases I cited in my brief, Mehmet and Yee. And those addressed the commission scenario, and that's what we have here. And under both the FLSA and in this situation, commissions are treated differently because they're different, because those commission employees are different. And there's no incentive when you have commission employees selling big ticket items to have them standing around working extra, paying them. They're only useful if they're making sales. If there's no demand, consumer demand, and it's, the store is dead, there's no incentive for an employer to have a bunch of commission people and ask them to work at a rate that's a sub-premium rate. That concern really doesn't exist in this world. The more important concern is that they receive compensation for their overtime hours, which the 100% commission pay plan does.
But wasn't that the case with the prevailing wage sort of structure that was at issue in Mullally?
Well, that particular structure.
Didn't they design it to sort of take into account any kind of overtime that would have been spent and needed to be compensated? Wasn't the prevailing wage in the overtime statute intended to sort of be enveloped within that structure?
Yes, Your Honor. But the thing with that particular case is, in that case, that their concept wasn't as good as the draw versus concept, because their concept ended up leaving people, the employees, holding the bag, and that they weren't fully compensated for their overtime through this structure that the employer in Mullally had designed. But here, the employees here have gotten time and a half for all of their Sunday overtime hours. It's not disputed.
Let's talk about the regulation, though, the 2703, subparagraph 3, second paragraph. Whether a non-exempt employee is paid on an hourly piecemeal salary or any other basis, such payment shall not serve to compensate the employee for any portion of the overtime rate for hours worked over 40 in a work week. What do you do with that language?
Well, I think, as Your Honor pointed out in my brother's argument section, we believe that segment there is simply intended to codify the fluctuating work week method of payment. That's all that was intended to do.
To the
But when
extent,
it was first put out as a draft, that didn't even have the fluctuating wage portion of it.
excuse me?
When it was sent out for comment, didn't even have the fluctuating wage portion of it, did it?
I don't remember, Your Honor, but I do remember that the notice did not contain anything suggesting that the Department of Labor Standards was looking at changing the two opinion letters that we've relied on, which are still in effect, that haven't been rescinded, and the Department of Labor Standards has rescinded other opinion letters, so we believe those are still good law, and that here, what the Department of Labor Standards was simply trying to do was to explain the fluctuating work week method. And you'll notice, even though it does say or any other basis, it doesn't reference a commission plan. And this definition here of overtime rate wouldn't apply to a commission plan because commissions and draw are excluded.
Fluctuating work week is not the same as commission, right?
No, Your Honor.
Okay.
What does that sentence mean at the end of the regulation? When overtime is determined on a bona fide fluctuating work week basis? What is, does that add anything to this? I'm reading, the whole clause is whether a non-exempt employee is paid on an hourly piece work, salary, or other such basis, such payments shall not serve to compensate the employee for any portion of the overtime rate for hours worked over 40, except this limitation only applies to the 1/2 portion, and then when overtime is determined on a bona fide fluctuating work week basis. What does that mean? Does that add anything?
Well, I think that adds something in to the extent of that manifests the Department of Labor Standards' intent to essentially state that they're accepting the bona fide fluctuating work week method of determining overtime, and they're trying to express that here. But-
Haven't you agreed, though, that this is not a fluctuating work week situation?
Yes, Your Honor.
So it has no application to these parties?
Yes, Your Honor.
Okay.
Yeah, we're not arguing fluctuating work week.
But you are saying that that second paragraph in subsection 3 is addressing the fluctuating work week.
Yes, Your Honor.
And you're saying that to understand what such payment means, you have to go to the paragraph above it, and it's such regular hourly rate.
Correct, Your Honor.
And the appellants say that makes no sense to read it that way.
Well, it may make sense to read it that way, but not in the commission scenario, because the legislature has expressed that commissions are not to be included in the regular hourly rate or the overtime rate, and neither is the draw. They're supposed to be treated differently. So this section we would submit does not apply in this scenario. And it's not when they say, I mean, they could have included, as opposed to this catch-all any other basis, they could have included a commission basis, which they didn't do. And they could have mentioned,
But what would have been some other basis that they could have had in mind?
commission,
For any other?
I don't know that an incentive is an actual basis.
Well, I don't mean to put you on the spot. If you think of anything, why don't you give us a 16L letter?
Okay, thank you, Your Honor.
But the language from the definition of regular hourly rate, it uses the same language. When an employee is paid on a piecework basis, salary, or any basis other than an hourly rate. But it goes on to say that commissions and drawing accounts are outside the scope of that definition. Correct?
Correct, Your Honor.
So your view is that they received essentially nothing pursuant to in actuality, they were not paid a regular hourly rate because the totality of what they were paid was excluded from the definition of a regular hourly rate.
That's correct, Your Honor. And then regular hourly rate from where Your Honor's looking at 2702 is then carried into this section of overtime rate, which is why we submit that this next paragraph, whether a non-exempt employee, that is not intended to address the commission scenario because those commissions and drawing accounts are expressly excluded.
So what makes this case complicated is that the overtime rate is generally 1.5 of the regular hourly rate, but the regular hourly rate here is 0 because all of their income is outside the definition of a regular hourly rate.
Correct, Your Honor, which is why the Department of Labor Standards has always looked to the minimum wage law and read the overtime statute and the minimum wage law together in harmony to require that for 100% commission employees who are paid on a draw versus commission basis, that those employees need to be paid 1.5 times minimum wage for all of their overtime and Sunday hours.
And that's why you say that DLS didn't have to send out any new alert in its 2016 publication, because it's your view nothing changed.
Correct, Your Honor. Our view is those 2 opinion letters are still in effect, and the DLS issued this topical outline after that, adopting it. They haven't rescinded them. And this all, hinges on this interpretation of such payments as applying to in the commission scenario, which we contend that it doesn't. We believe that the legislature's always intended to treat commission employees differently, and the legislature's always intended that the overtime statute be interpreted similarly as the FLSA, and under both statutes, they would not receive any extra additional compensation for overtime and Sunday hours as long as they're compensated at the adequate rate for all of those hours.
All right, thank you.
Thank you, Your Honor.